you have an existing business and it's generating a revenue, then you may be in a position to apply for a sole representative visa, but it's primarily designed for senior employees of overseas companies coming to the UK. So if you're an owner manager of such a business, you may have a shareholding which is, say, 100% or 60%. In these cases, you will not qualify unless you divest yourself of shares or dilute your shares for the purposes of coming to the UK. So there may be good business reasons for doing so. If you are going to take on a function in which the UK company is going to be led primarily by you and the decision making is going to be delegated to other staff or to a business partner so that you're not going to be involved, there may be reasons for doing this, which would bring you within the route. There may not be, and if there's not, then you would not qualify if you're the majority shareholder. You may have a group of companies though, and one of them will be expanding into the UK for a particular purpose. And in such a case, it may be that you do not have the majority of shares. So I think you need to consider the share position first. That's the main reason why people do not qualify if they don't qualify under the sole representative route. Now, the other point is, do you already have a presence in the UK? If you do have a presence in the UK, then you won't qualify for this visa. So you've got to be coming to the UK afresh, and it's got to be a new branch in the UK. The other point to bear in mind is that it's not intended for the UK to then become the headquarters. You've got to confirm in applying for a sole representative visa that the headquarters of the company are still going to be abroad. So unless it's a very long-term play, your headquarters are not going to be in the UK, it's going to be a branch, and that's what it's designed for. Now, let's switch over to the innovative visa route. So for the sole representative route, you have a 5-year lead-in, and that includes an extension application, in which you have to qualify for indefinite leave to remain. So it takes 5 years to get there. With the innovator visa, it only takes 3 years if you meet the criteria, for example, investing 50,000 in your business and engaging in research and development and applying for intellectual property of that. So you can have an accelerated lead-in to indefinite leave to remain in the same way as you can by investing £5 million in a UK company. That gives you a 3-year lead-in to indefinite leave to remain. But in this case, you only have to invest 50,000. Now, for the innovator visa, the 50,000 has to be invested if you're applying. You need to show it's available if you're applying immediately for that route and you haven't gone through the startup visa route. For the sole representative route, you do not have to have any investment in principle, but the reality is it's going to be no doubt a significant financial outlay to set up a branch in the UK, and it must be more than an off-the-shelf company. What I would advise if you are applying for a sole representative visa is bear in mind that you should not set anything up in the UK unless you get the visa, or until you get the visa. Now, in theory, having said that, unless you're actually trading, then it won't necessarily be a problem. But I think the prudent approach is just to take things in sequence. Do the visa application first, get the visa, and then start structuring, finding the office, setting up the bank account, etc. So back to the innovator visa, you've got a 3-year lead-in, and that's a clear advantage. You do have to play an active role in both. With the sole representative visa, you can only have one person, hence sole representative. With the Innovator visa, you can have several, and in fact it's without limit. So some of my clients are a gaming company, and the co-founders of that are actually four people who are coming over as co-founders under the Innovator visa route. So that's a good example. The only way to really bring people over under a sole representative visa after you've come in under that category is to set up a sponsor license and recruit them on work visas. However, that's subject to recruiting and running what they call here the resident labour market test. There are exceptions to that for shortage occupation roles and high earners, and I've spoken about those in previous videos, but bear that in mind. It's more restrictive. So if you're looking to come over with several people, the Innovator visa route might be a great choice. I also mentioned in this title the Start-up visa. Now, the Start-up visa is not a pathway to settlement, unlike the sole representative visa and the Innovator visa. The Start-up visa does not get you indefinite leave to remain. It is essentially a precursor to an Innovator visa. However, it can be useful for establishing the relationship with an endorsing body that would then endorse you for an Innovator visa. It's designed for early stage entrepreneurs, so you may be even at the concept stage and you could still potentially qualify. But the expectation with an Innovator visa is much higher. You have got to show that you can access international markets as well as national markets, and you've got to show that you're an experienced business person. There are no such requirements for the sole representative visa. The main thing that I see people being asked about in interview for sole representative visas is, what is the business case for expansion? Why are you expanding to the UK? Why are you seeking to do this? And a business plan is required in the same way as it is for an Innovator visa or Startup visa. But for a sole representative visa, the decision-making function is with the Home Office. But for the other two, it's with the endorsing bodies. So the Home Office has delegated its decision-making to endorsing bodies to decide which businesses can come into the UK. But for the sole representative visa, that decision still lies with the Home Office, and one of the main practical factors that they look at is your accounts. Do they demonstrate that you have a real business case for expansion to the UK, or is this purely speculative? Is there a compelling enough business plan? Now, I think that's problematic because it leads to inconsistency of decision making for sole representative visas. If you're refused, then that's a mark against your name under a sole representative visa. But if you're endorsed for an Innovator visa or Startup visa, then the overwhelming likelihood is your application will be granted. If you're not endorsed, then there's no mark against your name. You simply haven't been endorsed, and it's the same applies for the Canadian incubators and French incubators under the comparable routes. You simply won't be endorsed, but you have a clean immigration history. But with a sole representative visa, if you get a decision maker, entry clearance officer who takes against you or who doesn't really understand your sector and makes a poor quality decision, then you could be stuck with that subject to administrative review. So the safer course for some, perhaps for many, is to secure the endorsement. It gets you to where you want to be if you want to settle here faster, and you have, I think, less risk in terms of presenting your idea because of the position that I've just outlined, because if you're refused, there's no adverse impact. I hope that's helpful. If you're considering any of these three routes, I'd be very pleased to speak with you. I'm a lawyer based in the UK, and I head up a business immigration department at my law firm in London. We have 12 offices across the country, and we're a top 50 law firm. I'd be delighted to assist you if you are looking for advice. It's key to compare all of your visa options before you make an application, so just drop me a WhatsApp on the number below or email, and we can speak. Many thanks, and see you in the next video.